So now we go to section 222. Previously we discussed section 218 about the Pacquiao case. So you should know that. We go to section 222 for the other provisions. Just read. So about section 219, nature and extent of tax lien. So it's a lien on the property. So for the registerable property, then it should be filed within the Register of Deeds. And you have these forms, mode of proceeding in actions arising under this code. Just take note of this: shall be filed in court without the approval of the one, but no civil or criminal action, okay, for the recovery of taxes shall be filed without the approval of the commissioner. And you have this remedy for enforcement of statutory penal provisions, also with the approval of the commissioner. Discuss about section 222, which is all about period of limitation of assessment exceptions, because in section 203 you have 3 years, right? You remember that. But this is in the case of false, fraudulent, or failure to file a return. That's section 22. This involves false, fraudulent, or failure to file a return. In section 203, you have BIR has 3 years, to make assessment. But in section 222, if there's this false, fraudulent, or failure to file a return, then BIR has 10 years from the discovery of the falsity, fraud, or omission. Okay, so as I earlier discussed also, in Spouses Pacquiao, there was an issue there about prescription. But the fraud, because the BIR said it was fraudulent, the Supreme Court said the fraud contemplated by law must be actual. It must be intentional, consisting of deception willfully and deliberately done or resorted to, in order to induce another to give up some right. So that is the fraud that we're talking about. This is not just mere whatever. So whenever the BIR said it's fraudulent, that the filing of the return is fraudulent, that they have to prove that according to the definition. And also, BIR may assess in these cases, okay, file a suit without assessment. So let's go to the provision. There, here you go. So you just read this, and there is this case in the case of Standard Chartered Bank, CIR. This is all about the extension. Okay, the commissioner and the taxpayer can agree to an extension, provided that the extension is within the period to extend. So in the landmark case of the Philippine journalist versus CIR, okay, the Supreme Court defined or explained the nature of the waiver of prescription. A waiver is not automatically a renunciation of the right to invoke the defense of prescription. And it is actually a bilateral agreement, thus necessitating the very signatures of both the CIR, remember this, the taxpayer, give birth to a valid agreement. And it should indicate the date of the acceptance by the BIR. It is necessary, it is a must. Okay? In order to determine whether the parties had entered into a waiver before the expiration of the time prescribed in Section 203. So that's the 3-year prescriptive period for the assessment of the tax. I just remember the pronouncements here, because this might be asked about the nature of the waiver of prescription. Okay? And the Supreme Court went on to say it's because it results to a derogation of some of the rights of the taxpayer. Same must be executed in accordance with the preset guidelines and procedural requirements. What happened in this Standard Charter was that BIR or the waiver was in violation of the very regulations of the BIR. So Supreme Court struck down the waiver, and ultimately, well, the Standard Charter was not required to pay of the assessment, except for, if you've read this case, except for the creditable withholding tax and the vital withholding tax, which they paid, which they agreed to pay. And the BIR said, you're stooped from questioning the um, prescriptive period, etc., etc. And the Supreme Court said, well, you received or you accepted the payment without objection, so why would you now raise the issue of estoppel on the part of the bank? But that's it. You just have to understand that the prescriptive period, or the waiver of the prescriptive period, is not actually an automatic renunciation of the right to invoke the defense of prescription. Okay? And in case of false, fraudulent, or failure to file FFF, remedies must be pursued. Remedies of the BIR, the government, within 5 years from assessment. So what are the remedies? You have the distraint, the levy, and the collection suit. And in case of agreement for extension of 5 years to pursue collection from assessment, then the extension may again be extended upon written agreement before the expiration, of course, of the previous extension. Okay, so just remember section 222, exceptions to the period of limitation. So section 203 must be read in conjunction with section 222. We now go to section 223, suspension of running of statute of limitations. Now, you have this 3 years, you have this 10 years, and the 3 years can be suspended, or the running, it can be tolled, okay, on the prescriptive period. And the commissioner is prevented or prohibited from pursuing collection remedies. And 60 days thereafter, when there is a request for reinvestigation and was granted. This is in relation to section 228 class. Okay. You remember, you can file a motion for reconsideration or a motion for reinvestigation. A motion for reinvestigation tolls the running of the prescriptive period. So what does this mean? So when you file, there's this protest, okay? When you file your protest and you ask for a motion for reinvestigation, then the 3-year prescriptive period will stop, or the running of the prescriptive period will stop. Okay, it will be suspended because you just asked for a reinvestigation, and it's not fair for the BIR, because they will have to, the effect of that for your motion for reinvestigation is you're allowed to proffer additional evidence in your favor. Whereas in a motion for reconsideration, this is more likely in your favor, or the taxpayer's favor, because the MR does not toll the prescriptive period. It continues to run until the BIR decides on your protest, because the MR doesn't need, or the BIR doesn't need to look for any other evidences except for the ones which you submitted during the time. So it's a matter of a legal technique class on whether you file for a motion for reinvestigation or a motion for reconsideration. Well, that's in practice, but you have to know the difference between. We will discuss this later in section 228, but for the suspension, you just have to know motion for reinvestigation tolls the running of the prescriptive period. It favors the BIR, the state. And motion for reconsideration does not toll. It favors the taxpayer in the perspective of paying the tax. Okay? And when the taxpayer, again, the prescriptive period shall be suspended, the taxpayer cannot be located except when the BIR was informed of change of address. Okay? Next, we will go to section 228. These three provisions class are more or less related, especially section 223 and 228. For the other provisions, remedy for enforcement of forfeitures when property to be sold or destroyed, etc., etc. And Section 226, disposition. You just read this, and of course, you have to understand. Been repeating. But the more important provisions, I believe, are this is one that we've discussed. Okay, so we'll discuss Section 228 next, protesting and assessment.